As noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read all the written public comments. We thank you for that. The committee coordinator will attempt to call members of the public in the order that they appear. To facilitate hearing as many members of the public as possible, I encourage you to not repeat points that were made by previous speakers and to allow the committee the time needed to deliberate on the important topics that we will be discussing today. We will be limiting public comments to 3 minutes per person. For those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's the hand icon and should appear at the bottom center of your screen. If you wish to make a public comment, please click on that. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. The coordinator will call members of the public in the order that they identify, raise hands, and will enable the microphone of the speakers. Are there any public members that wish to make comment? Devin, if you can go ahead and check.
Our first public comment will be from George Leal. George, you've been unmuted. George, we can't hear you. Our next public comment will be from Todd Hill.
Thank you. Ladies and gentlemen of the committee, my name is Todd Hill, and I speak today as a former student of the People's College of Law, PCL, compelled to address the profound injustices that I and other students have endured under the watch of this institution. I want to take you back to December 2nd, 2022. On that day, the State Bar assumed its regulatory oversight of PCL, stripping the school of its autonomous degree-granting abilities. From that moment, every decision made by PCL regarding the education and future of its students fell under the bar's purview. Yet, despite this, I was unlawfully denied the Juris Doctor degree that I had rightfully earned. What makes this especially egregious is that PCL's actions were not isolated errors, but part of a larger pattern of discrimination and retaliation that mirrors the darkest periods of our nation's history. Just as de jure segregation once mandated discrimination by law, the segregation I have faced at PCL is no less harmful. This institution is engaged in the manipulation of academic records, denied me the opportunity to transfer, and subjected me to disparate treatment because I'm an African American. This is not just my story. It is the story of a system that has failed its students, a system that, despite being under the direct oversight of the State Bar, has perpetuated racial inequality. The very oversight that was supposed to protect us has, instead, allowed these injustices to continue unchecked. I have taken the necessary steps to address these wrongs. I filed the Government Claims Act form, submitted public comments, and presented a third amended complaint that outlines the full scope of the violations committed against me. But this is not just about following procedure. It is about holding institutions accountable to the laws and ethical standards that govern them. As the committee considers its next steps, particularly with the backdrop of an $8 million contract to revamp the California bar exam, I urge you to remember that the integrity of our legal system depends not just on how we test knowledge, but on how we treat those who violate the laws and norms of this noble profession. I'm not here to seek sympathy. I'm here to demand justice, not just for myself, but for every student who has been wronged by the very institutions meant to protect us. I ask that you take immediate action to rectify these injustices, starting with a thorough investigation into PCL's practices and the State Bar's oversight failures. I ask that you ensure that no other student suffers the way I have suffered. Thank you for your time, your attention, and I hope your commitment to justice.
Thank you. Our next public comment will be from Benjamin Cohn.
Hello, good morning. I wanted to address that At the time of the initial rule revision process, there was a resolution that I think was an unnecessary delay and bifurcation, but that you nonetheless passed to revisit the timeline issues once the rules that you were proposing in the first batch were in effect for 2 exam cycles. Those rules, according to statements that have been made in these meetings, have been largely applied, even though they haven't been adopted by the California Supreme Court, where they don't conflict with the face of the existing rules as sort of a pilot project, to my understanding. And I've heard from some of the disability rights orgs that that's their understanding as well for both the February 2024 and July 2024 exams. Given that those rules have seemingly given the data for 2 exam cycles, I don't see why there should be any further delay in getting the very lengthy ball moving on your internal processes to make a proposal on timeline reforms or to modify the omissions in your existing proposal if they are still, in fact, pending with the court. Now, my client, Ms. Kleisch, and the public interest orgs have no interest in waiting. The court is requested, to be sure, to adopt the requests that the commenters requested the first time and promulgate the appropriate timelines in this rule revision, but that as the court has not made its decision yet, there's no reason at this point with 2 exam cycles worth of data not to at least do some notice and comment depending on what the court decides to do. To increase the urgency of speeding it up, and I would note that among the civil rights organizations who have endorsed the 2-week timelines are some new ones in one of the briefs that was filed in the California Supreme Court, including the former longstanding employer of CBE member Brody, who I trust would take into reconsideration their position and their endorsement of the 2-week timeline. Lastly, I just wanted to note that your report on the February 2024 bar exam doesn't fully address the disparate treatment.
Thank you for your public comment. Our next comment is from Kristen.
Good morning. Thank you for your time. My name is Kristen Merriman, and I wanted to speak to the agenda item regarding Lincoln Law School's application for inspection. I am a product of the California school system. I graduated from a California high school. I wanted to be a lawyer then, but I didn't have the finances. So I waited tables and put myself through community college. I've worked for 30 years as a respiratory therapist. I put myself through San Jose State doing that. And then I got a scholarship to UC Davis. And I've kind of reached the pinnacle of my career as far as RT. I am currently the director at Stanford Medical Center of Respiratory Care. And my son in 2020 graduated high school and decided to go to college. And I decided that that was finally the right time for me to also follow my dream and go to law school. I picked Lincoln Law School because it is known in San Jose. I've been a resident or worked in San Jose for the past 30 years, and I always knew of Lincoln Law School and its reputation. In fact, my divorce attorney is a graduate. My local representative is a graduate. My experience with them has been nothing but positive. There have been some little hiccups, of course, with the administration. But as far as the instruction that they give, it is nothing but the best. I am working now on my 4th year of law school, my 13th year of post-secondary education. So I've been in a lot of programs, and I can't speak highly enough for the faculty. I started when it was remote. I thought that would be really difficult to adjust to, but it was one of my strongest years. Working full-time, juggling a family, we all do that. And I think that Lincoln has given us tremendous faculty. I've had district attorneys, I've had judges, but most importantly, the people that teach us are passionate about what they do. They're open to us. They allow us access to them to get private instruction or to get personal help. So they put in a lot of changes in response to the changes made to the bar exam. And I just really hope that you guys would consider moving them to inspection for reaccreditation. Thank you for your time. Appreciate it.
Thank you. Our next public comment will be from Gil.
Yes, good morning. Good morning, everyone. My name is Gil Rivas, and I'd like to also comment on item 3.3 on the consent calendar regarding the action for application for provision or full accreditation for Lincoln Law School of San Jose. I, too, am a product of the public school system. I was raised in Stockton, California. I'm a veteran of the United States Navy. After my naval service, I worked for a public utility, and I put myself through school, went to San Jose City College, San Jose State, St. Mary's. I received my MBA from St. Mary's College of California. And as to pursue further advancement in my career, I also took the opportunity at Lincoln Law School here in San Jose. And I concur with the statements made by the previous speaker. The faculty was awesome. The level of education we received from judges, other attorneys in the industry have been nothing but great. And the faculty is very supportive. Myself, I work full time. I'm a father, I'm a husband, and I don't see another institution that would afford the opportunity for folks to attend law school and receive a law degree and further their education and support the community and give back to different organizations they belong to or communities. It's also a place where everybody's welcome and you have to put the work in. There's absolutely nothing's going to be given to you. So in short, I would just hope that the folks here review that and everything Lincoln Law School has done and see the alumni that has produced and give them the opportunity of the accreditation or the provision warranted. Thank you very much for your time. Appreciate it.
Thank you. Back to George Leal.
Yes, good morning. Can everybody hear me now?
We can, thank you.
Sorry for the technical, my other headphones died. Good morning, members of the committee. I'm George Leal. You may recall I spoke before you in person back in January. I was the former dean of Fine College of Law, which recently closed as of the end of July. I'd like to speak briefly and try to make 3 points. I'm speaking with regard to the agenda item 4.1, that is the new passing score for the first year law students examination. I know I've been involved with the committee for over 16 years in several capacities as a member, as staff, and now as a dean. And I just want you to realize that you have one of the most consequential decisions before you today in terms of finally setting a fair and statistically valid pass score. The 3 points I want to make is first, due to the really excellent work of Dr. Bolus and now Dr. Buckenthal, we all know what we all suspected, which was the prior exam was statistically unsound in terms of having a passing score that was higher than it was necessary for its purpose, that is to be correlative to future success on the CBX. And as Dr. Bolus reported to the committee last August, he made 2 critical findings. The first was that the current exam, which was 7 hours, the bar exam is only a 6-hour-a-day testing. First year exam is 7. That included 4 essay questions, was not as valid, was not as reliable as what it is now, a 100 question 3-hour exam. So one, it wasn't as reliable. And secondly, as he reported to the committee, and to, again, Dr. Buckenthal's credit on page 8 of his report, he made a very candid but startling finding, which was the prior cut score, passing score, was higher than it needed to be. So the second point is, with regard to the regulation of unaccredited registered schools, is the committee is the Supreme Court of California. As you should know, you have full statutory authority to regulate the first year exam, its form, its content, and its passing score, as you do with regard to the operation of all the registered unaccredited schools. You have more authority to do that than even with regard to the CALs in terms of statutory authority. So what I'm urging you to do is to do what the Supreme Court of California did. It saw fit to reduce the CBX cut score by 3.5%, going from 1440 to 1390. The recommendation the committee has is that you set the score at 70. I'm urging you to set it at 69, which would be an equivalent reduction in the old, out-of-date, and needlessly high cut score. I'd urge you to look at Professor and Dr. Buckenall's report. It's thorough, it's accurate, and I know that your decision today will have the direct effect on the lives of perhaps scores of students, because under the old exam, it's now established that hundreds, if not more, students were needlessly dismissed because they couldn't pass what is, we now know, statistically proven to have been an unreliable and exam that was scored at too high a level. So I hope you do the right thing, as the Supreme Court did, in terms of promoting diversity in the profession, because there are probably scores, if not hundreds, of students who would be practicing law today, most of them are people of color in lower socioeconomic levels, who lost the opportunity to complete their legal education, earn a degree, and pass the California bar because of the exam, the first year exam that barred them, kept them from doing so. Thank you for your time, and I hope you do the right thing. Appreciate the opportunity to speak to you.
Thank you. We do not have any additional members of the public on Zoom that wish to make public comment. Are there any members of the public in person that wish to make public comment? Seeing none, we have no additional public comments.
Thank you. Thank you so much, Devin. This concludes the agenda for public comments, and we will now proceed with the open session agenda items. We're going to start with agenda item number 1, which is the chair's report. Today, I want to take a moment to recognize Jim Efting for his exceptional and phenomenal service on the Committee of Bar Examiners. For 8 incredible years, Jim has been an invaluable member of this committee, including serving as chair or vice chair of numerous subcommittees over his 8-year dedication to public service. His dedication, his professionalism are exemplary. Jim is so thoughtful, he has such a measured approach, and he's really instrumental in guiding us through these numerous policy decisions that we have to make, which are not easy. His contributions have been significant, and Jim, we're really and truly grateful for your expertise and your leadership. Unfortunately, this is Jim's final meeting, and we really mean unfortunately. And, we understand is because Jim has decided to not seek reappointment because he wants to spend time with his family and his grandchildren, which are, the number one priorities for all of us. So I want to really ask everyone to give a really warm round of applause to Jim for his outstanding service. Jim, would you like to say a few words, sir?
Well, thank you very much. It's been a pleasure to be able to serve on the committee and help, I think, hopefully help a lot of people along the way. I really met a lot of good people I like, and looking forward to continuing my relationship with all of you. So thank you very much. Bye.
Jim, can we have you come up here, Jim? We'd like to give you a small token of our appreciation for your years of dedication. Jim, this is just a small token, and we want to say thank you so much for your dedication to the public as well as the Committee of Bar Examiners.
This is great. Thank you very much.
So moving on with some small housekeeping notes. We do have 2 special set presentations today. The first one will be at 9:30 a.m. and the second one will be in closed session at 11 a.m. We will have a 1-hour break for lunch around noon today. So continuing with the chair's report, we're going to move to the Committee of Bar Examiners work plan. I had asked staff to provide me with an update on the work plan, and that's attached to the agenda meeting for today. So we're going to ask for updates from each area since the last meeting. I'm going to go ahead and ask Tara if you could please start the updates for the work plan.
Good morning, everyone. Give me 1 minute to share my screen, please. Okay. So good morning, everyone. So there were just a couple of updates we wanted to point out. First, I'm going to go to the rules regarding the multi-jurisdictional practice and foreign legal consultant program. Initially, it was on the work plan last meeting for either this meeting or October. However, due to time constraints with some of our partner offices, it is going to be pushed to the October meeting, but that will still get it to the Board of Trustees in time for their November meeting, assuming that you all decide to approve it. And then if we go back up to the testing accommodation section. Yeah, nope. I know, it's hard to do this. Okay, and I was gonna ask Christina to get the update on this one. Yeah. So we just updated the analysis of the new rules to be after the court has actually approved them. I think you heard during public comment that we have implemented some of the revisions from the rules, but since it hasn't been fully implemented yet, we're going to update that with a date that's appropriate once the court has actually decided on them. And that's all I have for our section.
Adrian, do you have some updates on the work plan?
Morning, everybody. Tara, do you mind scrolling to the, looks like it's the page of top of page 4. So we have an update for consider conducting a standard setting study to determine whether the passing score for the first year law students exam should be raised or lowered. As some of the public comment mentioned, we do have an agenda item today regarding this. So this would be completed at this meeting. So it's noted as August 24 for completed. Then another update would be for bottom of page 5. A presentation from the examination development and grading team on the basics of essay question development. We did want to push that back to the following committee meeting to go in line with the presentation from the PT drafting team member on the basics of PT development, which was already scheduled for that meeting. And then I believe there's one more that I had. Middle of page 6, consider draft reports to the Supreme Court of California on the July 2023 and February 2024 California bar examinations. Regarding the February 2024 California bar examination, this report is going to be presented today at this meeting, so we did mark it as completed for this month. And I believe those were all my updates.
I think those are all the updates overall.
All right, thank you. So moving on, we will continue following the open session agenda item. We will go to approval of the January 21, 2024 open session minutes. I'd like to get a motion for approval.
So moved.
Thank you, Dr. Bolton. Thank you, Alex, first and second. And then are there any discussion or edits on those open session minutes from the committee? Okay, seeing and hearing none. Devin, can you go ahead and do a roll call vote?
Dr. Bolton?
Yes.
Robert Brody? Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora? Larry Kaplan?
Yes.
Paul Kramer?
Yes.
Alex Lawrence?
Abstain.
Esther Lynn?
Yes.
Justice Macy Walla?
Abstain.
Bethany Peak? Ashley Silva Guzman,
Abstain.
Judge Reyna,
Yes.
Vince Reyes, Alan Yokelson,
Yes.
Dr. Cow.
Yes.
With 10 yeses and 0 nos, the motion passes.
Thank you, Devin. Moving on to the consent agenda. That's agenda item number 3 on the open session. The consent calendar is voted on and is approved as an omnibus item, meaning one vote for the entire calendar unless a board member decides to post something off the consent calendar. I'd like to see, are there any questions or comments on the consent agenda? Seeing here none, can we get a motion and a second for the consent agenda?
So moved.
Thank you, Paul. May we get a second?
I'll second.
Thank you, Majestis. So are there any discussion or debate, any items that a board member would like to pull? Okay, seeing and hearing none. Devin, can we get a roll call vote?
Dr. Bolton,
Yes.
Robert Brody, Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora, Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Macy Walla,
Yes.
Bethany Peak, Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes, Alan Yokelson,
Yes.
Dr. Cow.
Yes.
With 13 yeses and 0 nos, the motion passes.
Great. This is perfect timing. So we are now moving on to agenda item number 4, which is the under the business section. So we have the special set at 9:30 a.m. Is it close enough?
We're exactly at 9:30.
We just need to promote Dr. Buckendall, so maybe we just can take 2 minutes to wait for him.
We're taking a 2-minute break, waiting to promote Dr. Buckenthal. a.m. So we will be discussing agenda item number 4.-1, review and approval of standard setting for the first-year law students examination, the special set. I'm going to turn it over to Adrian.
Sure. Thank you, everybody. For this item, we do have Dr. Chad Buckendall who oversaw the first year law students exam standard setting study that we recently completed. Can he be promoted? There he is. All right. I just want to introduce Dr. Chad Buckendahl. He is from ACS Ventures, our psychometrician, and he did oversee the standard setting study that we completed from July, and I think it was, they had 2 meetings. I can't remember if it was completed in July or if it led into August as well, but Dr. Buckendahl, go ahead.
Thanks, Adrian, and thanks, members of the committee. I do have a short presentation to share with the group, and then we'll be happy to respond to any questions. And so let me pull that up. So as Adrian noted, we engaged in a standard setting process, which is usually kind of the end stage of a redevelopment activity for an examination program. Standard setting is kind of the technical term that is used. It's more commonly probably thought of as a passing score or a passing point study. You'll see that sometimes in the literature. And it's a systematic activity in which you evaluate the ease or difficulty of questions on the examination, and then using a policy definition of minimal qualifications, then come to a recommendation for the passing score that is then deliberated by a policy body like the CBE in order to make that final determination. The purpose of the presentation, I'm going to do a very quick overview of the process that the panelists engaged in with this activity. I'm going to provide a summary of the item level statistics from the June 2024 exam for the applicants, the students who took the exam, and also provide some information on the impact data, both the current and historical, as part of the conversation. Talk a little bit about what the panel also discussed with respect to how their recommendations would connect to the purpose of the examination. And then finally, share with you the passing score recommendation and range, along with the rationale that the panel provided. So in standard setting, although there are a number of different methodologies that can be used in order to recommend a passing score for a licensure or a certification, or in this case, the first year law students exam, the steps are generally contained in any of these studies, and that is a panel of qualified, we call them subject matter experts, but really the key qualification characteristics are that the panelists are familiar with the content that's being tested, as well as the characteristics of the target population of examinees who are actually engaged in the test, because they have a kind of a knowledge and familiarity of where those abilities are kind of at the point that the exam is given. And so that first step in a standard setting is understanding what the exam is used for and what a pass or fail decision means. The second step then is to discuss what the content is on the exam. And again, for those of you who are probably very familiar, the content of this examination is focused on equivalent representation of criminal law, contracts, and torts, as well as, in this case, the item types. So how is this content being measured, and how is the content being scored? There is then a facilitated discussion of what does it mean to be minimally qualified, as in what are the characteristics of somebody who is at the threshold level of performance of meeting expectations after having completed a first year course in these subject areas. Panelists then provide initial ratings. In this case, they used an Angoff methodology. It's named after a researcher named Bill Angoff, who published the book chapter, I guess, in 1971. So the methodology has been commonly used in one variation or another for a little more than 50 years now. And because this is an iterative process that is an integration of policy and content and psychometrics, what happens after those initial ratings is there's a discussion of the results and an opportunity to refine or come to consensus on the ratings in order to form and then ultimately a recommendation to the CBE. So for the group was asked to evaluate 100 questions. So the form of the test that was given in June had 100 questions, of which 90 will be scored, and I'll come back to that in a moment. And so what they were asked to do is make a judgment about whether or not, after going through those steps that I just mentioned in terms of training, whether or not a minimally qualified student having completed a first-year course would get each question correct or incorrect. And so these data are really a summary then of what they recommended. You can see along the bottom row that we had a pretty wide range after the first round of judgments that ranged from any, at least one person said that student should answer 51 out of the 100 questions correct. We had one person that said they should answer 91 out of the 100 questions correct. And you can see how those ranges then broke down for each of the individual subject areas, as well as then the overall mean and median. The mean statistically is just the average score. So the average recommendation for the group was just under 75. The median recommendation, because of some outliers towards the top end of the scale, was at 81. The standard deviation is just an indicator of variability, meaning how much spread was there on an average basis for our panelists. And then that final column there was information that was given again after the first round to indicate here's how students actually performed on these sections with the average score by each of the 3 subject areas, as well as overall. That was provided as a point of reference for the discussion. Again, you can see that the expectation was right around about somewhere between 23 and 25 of the questions for each of the subject areas, which then totaled to about 74, 75 in terms of the initial recommendation for the average. And this, again, notably was higher than the average score. The average score for the participants, or sorry, for the students who took this exam was about 60 questions correct out of the 100. So the expectation of the group did exceed the average performance for students who took the test. The next piece of information then that we discussed after the initial round of judgments was we talked about something called item difficulty statistics. So each question on the test can be evaluated in a number of different ways, both qualitatively and then statistically. One of these statistical elements that we look at to evaluate whether or not questions are functioning well is something called a p-value, or item difficulty. That p-value simply stands for the proportion of students that took the June exam that answered the question correct. There are other statistics that we use that look at the correlation, for example, between individual item level performance on the total. We also look to see if the response options for multiple choice questions are things like A, B, C, and D. We are looking to see if those are functioning appropriately so that we can continue to use the question, or there's not a concern with the question. For this particular test, you'll see on the far right, I've kind of indicated that when questions fell within a range of 85% to 100% correct, meaning p-values of 0.85 to 1.00, these are generally questions that are too easy. They're not really providing a lot of value in terms of differentiating somebody who is at that threshold level of meeting or not meeting that policy standard. And then you'll see the distribution of items generally fell within a range of about 0.3 to 0.84. most of the questions falling somewhere between 0.4 and 0.84. Because a number of the questions on the test have been used previously, we did expect that to be the majority of items on the test. Those items kind of fall right into the sweet spot in terms of what we look at statistically for questions on exams like this. We want it to provide some information that will help us make that determination. Questions that are too difficult, meaning that we are really falling below that 0.30 threshold and really almost approaching like a chance probability of getting the question correct. Those types of questions, as well as the questions that are too easy, do not provide much information. So you can see, meaning much information that helps us make that decision of pass or fail. So you can see that there were actually very few questions within each of the subject areas. So within criminal law, there were 3 questions that didn't function as well as we'd like. Within contracts, there was also 3. Within torts, there were 6. And so, as I mentioned earlier, one of the reasons why there were 100 questions on the test is that we know that 90 of the questions are scored. And if there are any questions that don't function well, having a few of those extra questions on the test gives us that flexibility to remove questions that don't function well while still maintaining the blueprint of having 30 questions coming from each of these 3 content areas. And we try to maximize information so that we're getting the most reliable score. And so for the 100 items, the reliability was 0.88. Reliability falls on a scale from -1 to +1. Positive numbers are always desired. Positive numbers above 0.85 and as they approach 1 are suggesting that we are a lot more confident in any decision that we might make using scores from those tests. You can also see from the difficulty statistics on screen that criminal law was the most difficult section. The average p-value for questions in that section was 0.58, meaning the average question had 58% correct responses to it. Contracts was then the next most difficult, 61% average difficulty. Torts being slightly easier than contract, 62% difficulty. And on the 100 questions, you can see that although contracts has a higher average total, that's because you'll also notice that they had 1 more question. There was 1 additional contract question compared to the other ones that had 33, contracts had 34. The overall difficulty, again, illustrating that for the students who took this, the average number correct was about 60, just slightly above 60, with the average difficulty then meaning that the average difficulty was 0.6 or 60% correct for questions on the test. So the panelists use this information to then kind of evaluate in a more holistic way, okay, where were our recommendations relative after round 1 relative to how students actually performed? And so showing them this item difficulty information gave them a sense of the relative ease or difficulty of the test that they could use to factor into a second judgment that we discussed as a group. So the initial passing, the initial pass rate, if we use that passing score of 74.5, meaning it's either 74 or 75, depending on your rounding rule, that would mean that for the June exam, 13 to 14% would have passed the exam if we use that particular passing score. Now, as I mentioned, standard deviation suggests that when we're looking at a distribution of scores, we know that there's, think of it as almost like a margin of error, right? There's plus or minus some gray area around that average recommendation. And so to try to represent that, we provide a range that if we were to go 1 standard deviation below, that would get us to about 68.6 as a passing score, which approximates to about a 28% pass rate. If we go above that recommendation to 80.4, that would reduce our pass rate to 5%. So this is kind of showing you, based on the panelists' recommendation, initial recommendation, what that sort of range is, both in terms of the passing score itself, as well as the potential pass rate associated with those recommendations. In addition to this information, we also provided historical pass rate information specifically from the June exam, because we know that the June exam and the October exam, the applicants or students who take those are not identical in terms of the ability distribution. And so we wanted them to have some sense of, well, what sort of comparative data should we be thinking about? So we use something called equipercentile equating, in which we say, okay, if we were to take the 2018 passing rate, what would that look like in terms of a passing score from this June 2024 exam? If we were to take the 2019 pass rate, what would that look like on this particular exam? And we did that for the last few years, from 2018 to 2023. And you can see that that ranged from 70 to about 74. So 70 at the lower end, 74 at the higher end, with an average over the last 6 years of 19.88% as a passing rate, with that would correspond to a passing score on the June exam of 72. So that's the sort of information from both from a group level information, student level information as interpreted by statistics on the exam, and then now what does that mean in terms of impact? So what we asked the panelists to do was to consider kind of the collection of this information and think about a few questions as we were talking through this. One, that first question, what's changed in the target population of applicants taking this particular exam over the last 25 years? We know that the passing score hasn't been modified in a number of years. And so we wanted to think about, have there been changes to the population that could influence how we interpret performance? We also wanted to know, okay, what was the recommended score or range of scores, right? So their initial range of scores was about plus or minus 6 points. Could we narrow that? Could we bring that, down a little bit to have a better sense of where they think the recommended passing score should be? And then will that recommended score or range of scores continue to support the purpose of the exam? The purpose of the exam being really kind of twofold. One, and I think, and I suppose there could be argument as to which the primary one is, but my interpretation of the primary reason is that this serves as a measure of public protection and consumer protection, so that individuals who are participating, who are required to participate in this particular exam, that they have kind of full knowledge of where they are in terms of their on-track performance to ultimately potentially pass the bar exam. That secondary purpose is the exam does serve as kind of an indicator of where they are and can help them make a decision as to whether or not to continue to pursue a career in law or not. And so the panel had a really good discussion about how their initial recommendations, and in some cases, we had a couple panelists indicate that they misinterpreted the judgment task in the first round and were making some ratings based in part on whether they thought a question was appropriate to measure first-year law students, not necessarily whether or not the first-year law student would answer the question correctly. And so that's another reason why multiple rounds of judgments or discussions that occur in this, because it is a complex task to integrate these different pieces and to ultimately formulate a recommendation. The outcome then of the discussion after we walk through some of these elements, and there is one more piece of information that kind of comes into the rationale that I'll mention here in a moment. But the panel then ended up narrowing their recommendation to a spot that was just higher than one standard deviation below their average recommendation, you remember their average recommendation was 74.5. One standard deviation below that would have been 68.6. And so they went just above that to say, okay, 69 is kind of the lower bound of what we might recommend, up to 71. So not quite to the level of the average recommendation, but somewhere around there with 70 as the midpoint for those 100 questions. Part of the rationale for that recommendation was, again, their judgment about the ease and difficulty of the questions for the students, but also some of the prior research and comments in prior presentations from Dr. Bolus about the passing score. And in particular, one of the studies that Dr. Bolus has done a couple times over the years is an evaluation of the predictive nature of applicants who take this first-year law students exam and the likelihood that they then have to pass the bar examination. And the kind of the evaluation of that is, at what point, at what score do we start to see that students would have about a 50-50 chance to pass the bar exam based on their score on the first-year exam? Well, one of the things since that research had occurred, the passing score for the bar exam has been lowered from, I think it was 1420 previously, and I think it's 1390 now, if I remember correctly. But Adrian, correct me if I'm wrong on that. So in doing so, that relationship then shifts a little bit. So when the bar exam passing score was lowered, there was not a kind of a corresponding adjustment to the first-year law student exam. And so at the point of redevelopment of the exam, removal of the essay questions and a focus on the multiple choice questions, this is kind of that opportunity to use the information that we have in combination with Dr. Bolus's research to then ultimately formulate the recommendation that the group made. Ultimately, the final recommendation that the CBE provides to us today will be equated to the 90 questions that are ultimately scored. So as I mentioned, these recommendations are based on 100 questions in the test, not on the 90 that would be scored. And the 90 that are scored remove some of the questions that did not statistically function appropriately, and we carry forward then the recommendation and apply it to that scale so that we're not changing the meaning of what you would be ultimately authorizing today. This also then serves as a baseline for equating future exams. So what happens is once a passing score is set, we statistically equate to ensure that as forms of the exam change and applicants change, that we don't change the meaning of that passing score and make it normative. The goal is to maintain a criterion reference interpretation, and that's what's been done over the last number of years. And then this essentially establishes a new baseline because of the redevelopment of the exam. And so again, and in summary, the process by which the group engaged in resulted in a recommendation of a 69 to 71. And if pinned down, they said go right to the middle with a 70, with the rationale that you kind of see on screen. And so with that, I'm happy to respond to any questions.
If there are members that have questions, open it up. Alex?
I'll start with a basic question. So right now, the passing score is 560. And just to refresh our memory, how does that convert, I guess, based on your scale, if you would convert that number to the current scale, what would that be?
So it would be a 560. So the 560 is anchored as a location on what we call an interpretive scale score. And so whatever the kind of raw score number you recommend today, that will be basically anchored at a 560. And then from there, it's a linear transformation just to put numbers above and below on that interpretive scale. Very similar to like an exam like the SAT that's always reported on a scale from 200 to 800. That 560 doesn't change. That's going to continue to be your reported cut score. even if the underlying raw score is a value that may shift slightly each exam depending on how easy or difficult the new versions of the exam are.
Thank you.
Couple questions. Did we compare the relative difficulty of this exam with the previous ones? Or are we basically resetting the baseline? If, for instance, this one was a lot easier or tougher, I assume we will scale against it in the future, correct?
Yes, we will scale against it in the future. And let me, I will go back for just a moment and to share what that comparability was. So and if it gets there. So what you can see here is with the historical data from the prior June performances, you can see that most of the values fall somewhere between 70 and 74 in terms of the pass rate. And so what this is telling you is that the relative difficulty of the exam is pretty similar. It's probably within about plus or minus 3 to 4% each June administration. So the difficulty of the test has remained relatively constant. And that is in part because over a number of years of administration, we know the characteristics of the items. And so the stability of those characteristics over a long period of time and over large samples tends to remain fairly stable.
It's probably easier to scale those than essay questions, for instance.
Yes, sir.
It could vary a lot. Okay. So there are 10 of the questions as opposed to the 90 are just test questions, in effect, your trial questions, just checking them, trying them out. But if somebody answers those correctly, are they counted towards their score?
They're not. So only the 90 scored questions count. And part of the reason, sorry, go ahead.
No, go ahead. So this is 70 out of 90 then they have to achieve?
No, it would be 70 out of 100. It would be 63 out of 90.
Okay, gotcha. So it's a percentage.
Yeah.
Okay, go ahead. The rest of your answer. Sorry.
Oh, yeah. Just as I mentioned, for the 100 questions, the reliability was calculated to be 0.88. In removing those 10 questions, the reliability actually improves to 0.89 because there were about 4 or 5 of those questions that had really poor statistics and actually kind of reduced the reliability because of just poor characteristics in the question. And so that's another reason why having, a few experimental or pre-test questions on the exam can be useful, because if you have a question that doesn't function, you can swap that out for one that did perform well in the same content area. And you have like a little bit of cushion to remove questions that don't work well and kind of work against you.
Okay. I see the main value of this test as protecting the consumers, and in this case, the consumers are the students, to tell them that, hey, maybe this isn't your path. After their expenditure of 1 year's worth of tuition as opposed to 4 years and a lot of bar prep. Are there any other, I'm having trouble putting my finger on any other purposes for this exam. Do you have any in mind, or does staff?
Can I comment? It sounds to me the purpose of the exam is somewhat to be, lack of a better word, big brother. Basically telling people you can't proceed if you can't pass this test. And that's something that bothers me. It's one thing to say you have difficulty and you're at the low end of the scale. It's another to say you just can't participate in law school anymore.
Yeah, your dream is, well, I mean, it's in the statute, I think, now. So we're currently, well, I guess we could set the cut score so low that more dreams would be allowed to continue.
Well, I'm not saying eliminate the exam or cut it too low, but I think you have to, I think 70 is a little high, at least I guess what I'm thinking. I'll say it now rather than later.
You think it's okay or too high?
I think 70 is too high. I would go to 68 or 69.
Okay.
I'll say it now rather than later.
Okay, my final question then, we probably have to wait at least 5 years, but are we planning to revisit Dr. Bolus's study about the predictive value of the exam? You know, we need to wait 4 years because only the first of these students will be starting to take the bar exam, but I'm hoping that we'll revisit that. I'll reveal my opinion. I'm just kind of uncertain about what the right answer is here. And the methodology of having people just, you know, look at the questions and compare them to their own picture of what a, you know, what an minimally qualified applicant is it all seems kind of voodoo-ish to me, but it also appears that this is the best we can do, and I'm comforted slightly by the appearance that this standard would not change the pass rates appreciably, so we're not opening up or closing down something that, you know, from what we've had up till now. But nervous be me.
Are there other questions for Dr. Buckenthal from the CBE members?
Chad, I have a couple of questions for you. So you used the last 6 years worth of pass rates for your average from 2018, 2023. Based on my experience, we always use the last 10 years worth of data, and especially the last couple of years where I sort of consider 2022 and 2023 are outliers because of COVID, and a lot of students were impacted adversely. And so, and you can see a huge dip, right, in passing rate in 2023. That, from my speculation, that would be probably because of COVID. But is there any reason why we didn't consider the pass rates prior to 2018? Because I think that would provide a little more reliability in terms of what the actual pass rate is. Because if we were to take out 2023 together, I think the average would be probably a little bit higher in terms of the pass rate. But give me your thought on the reason why you chose 6 years versus 10.
Yeah, that's a great question, and I think part of the reason was to try to mitigate two confounds that could influence that average. You absolutely identified COVID as something that could influence the learning opportunities for students during, you know, the 2020, 2022 that may have this sort of I don't know, lingering effect on performance. And then I think part of the reason that I didn't want to go back too much further than 2018 is because we also know that the population of students who took this exam over the years, that it's changed as some schools have moved from unaccredited to being I think it's California accredited. I kind of forget your designations. So your population characteristics have shifted a little bit. And so a slight downward trend is probably not unexpected, as some of the students who would have been previously eligible to take the exam are now no longer eligible or no longer required to take it. And so I think trying to balance those two confounds, and yeah, honestly, anything right now where there's a meaningful learning component, whether it's in the K-12 education space or in this sort of exam, that COVID effect from like 2020, 2022, even in 2023, there is something there that is going to take a while, I think, to kind of work its way through the system. The one thing, though, I guess all I'll say is that with what Mr. Kramer was kind of saying before about not exactly sure where to go, we were able to draw on Dr. Bolus's research to at least simulate or approximate what that relationship might look like in 4 to 5 years once that longitudinal data are available. And so, as I mentioned, Dr. Bolus's report took a look at the kind of the predictive relationship between passing the first year exam and then ultimately the bar exam. And this was both kind of under the old bar exam pass score and the new bar exam pass score. And we kind of used that point, that anchor point of we wanted at least 50%. So if we're saying that somebody passes this exam, the policy determination at some point is kind of saying we want students to have at least a 50% probability of success on the bar exam if they pass this exam. And so by lowering the score too much, all you're doing is then lowering that probability of eventual success based on the longitudinal data that Dr. Bolus presented. Now, conversely, you could say, well, listen, a coin flip isn't good enough for me. I want to be 70% sure that they're going to pass the bar exam. So that then becomes sort of the policy deliberation and the competing philosophies about, is the first year exam intended to be, a very wide funnel to permit as many people as possible to kind of continue on their pathway, and only for those who we know really have a very small likelihood of passing to be held back from that. Or is it, no, we want to have some sort of reasonable estimate that they can succeed if they continue under that consumer protection mindset of continuing to spend money on tuition and fees and the associated time associated with pursuing this pathway.
Another question I have, I'm just looking at the panel that compiled the recommendation. I see they're all deans, and many of whom are deans at unaccredited law schools. So I feel like, it's sort of a no-brainer in many ways, and perhaps that could have introduced some potential bias, and this is based on my personal opinion, that as to why there are no other lawyers other than deans on the panel in choosing or making the recommendation. But that being said, looking at your midpoint, the 70 midpoint, what would be the predictive passing rate equivalent to 70?
And that's actually, that 70 corresponds approximately to the 50%, the 50% likelihood of success on the bar exam with the new cut score of 1390 on the bar exam. And with respect to the panelists, yeah, it's, again, qualifications of the panel are always an important question. And again, I don't want to reveal like individual panelist recommendations, but I can say kind of in summary, there was not an attempt by the deans or participants from unaccredited law schools to try to bias or influence the process downward. If anything, they tend to be kind of at the upper end of that range that I shared. And I don't know, Ashley, you were actually a member of the panel. Could you speak a little bit to the maybe the group in terms of both qualifications and kind of the dynamic of conversations?
Yeah, I think, I glitched a little bit. I think that honestly, this was the best choice of panelists to have making these kinds of decisions because they're working with these students every day. I don't really know any other panelists that would be as uniquely situated or prepared to make those decisions as the deans and practitioners who are working with these students every day. And kind of what Chad was talking about is that, without disclosing too much about what went into that process, they actually tended to be a little bit harder, right? Because I think because they are such, big powerhouses in their fields. And so I think that definitely lent into the numbers, and it took a lot of back and forth amongst the panelists about what those goals are of the first year law student exam. I think that, after going through the numbers, I personally think that, that number that was being thrown around 68, 69 is probably something that I would recommend more so than the 70. The 70 is a good midpoint. If we wanted a midpoint, it still correlates pretty nicely with that expectation for the bar exam. But I think that we would also benefit from, maybe looking at a reduction to a 68 or 69, which would also meet some of those, meet some of those expectations of passing the bar, but also meet some of our goals of not being kind of these big arbiters of who can and can't continue on to finish law school. So as far as, panelists go, I think that we had a uniquely well-situated group of panelists to make that decision. I was probably the least impressive, so or least well suited. So I was glad to be a part of it, which was I think very educational. And so if anyone has any questions about what that looks like from someone like me who's within their first 3 or so years of practice, I can definitely answer any of those questions as well.
Chad, do you want to, it might be helpful to go over again the impact of like a 68, 69, 70 as the committee looks to make that decision?
Sure. Let me pull that back up. So in terms of the impact, the recommendation of 69 would end up being about a 28% pass rate. So if I were to actually, oops, can't highlight there. So a 69 gives you about a 28% pass rate. A 70 puts you closer in line to about a 23.5% pass rate. A 71 is about a 22.5% pass rate. And you can kind of see that from the historical data here. So from 2019, so we see that the 69 would be a 28% pass rate. A 70 would be about 23.5%, 71 about 22.5%. So that's kind of the range you're looking at, is somewhere between about 22 to 28% is the upper and lower bound of what that 69 to 71 is. At a 68, if you were to, drop down to a 68 and just truncate that 68.6, the number I believe is 29.4% or something. So it's about a percent higher than what you see here on screen.
Dr. Buckenthal, this is Michael. I have a couple questions. So first, the first question I have, and I wasn't sure if you had mentioned in your presentation. So the pie of students is how many students?
It's just under a couple hundred.
So a couple hundred students per year, that's the pie. And then what you're saying is that if you do a 1 standard deviation below the mean, it's a 28% pass rate. But then based on Dr. Bolus's study, you said that 50% of those students who pass the first year law student exam would then pass the California bar exam. So 28% and then only 50% of that 28, so that's 14% of students will ultimately only pass the California bar exam to be able to practice law. Is that correct then?
Yes, that's a correct interpretation. So, and it's probabilistic, because in some years it could be a little higher, it could be a little lower, but that's the sort of kind of predicted value that if they meet this score on the first year exam, they have a 50% probability of then passing the California bar exam when they take it.
And then the second thing you mentioned during the discussion was that about the demographics had changed. Alex's question about, why not before 2018, and is that you said the demographics has changed. So how do you account for that demographic change from Dr. Bolus's study to your evaluation?
Yeah, that's a good question. And because Dr. Bolus's study was based on longitudinal data that was kind of inclusive of some of those changes, it's frankly just kind of like a confound in the interpretation. I can't account for it directly because the relationship, so if I were to take the relationship from say 1990 to 2000, that could be a slightly different relationship than from 2000 to 2010, for example. And that's where I was saying, like, when you kind of reverse engineer, well, what would be the passing score at this impact? You are still kind of approximating and making an assumption that there is some at least equivalence, random equivalence in those comparisons of the population. And that's where I don't know enough about the population characteristics. I know that some schools have either transitioned to California accredited or they've closed. And so there have been probably some on both sides of what that equation is. And so is it a wash? I'm not sure. To know that, we would have to kind of dive in a little bit more to maybe specific questions about population.
And then the next question I have is the midpoint of 70, that was just like a happy number in between both. Was there any statistical reason why you decided that, not you, but the committee, the task force decided that midpoint is 70?
I don't know. Ashley, you may want to speak to this one too. I think it was, we had that lower bound from the statistic of the 68, 69. And then above that, there were, some recommendations from the historical data. And I just think, with some policy compromises, that probably is how it got there. But Ashley, could you speak to that a little?
Yeah, that I think pretty much summarizes it. I think we found a happy medium based on the comparison to previous statistics, our kind of assessment of what a first-year law student should know, and those policy considerations of, do we want it to be an outlier of how hard it was to pass this one, which I think none of us wanted that. So that's where we were.
Sorry, I have one last question. We're talking about quantitative 70, one standard deviation, the pi is a couple hundred. But my next question is actually a qualitative question. And the qualitative question I'm asking is that with whatever number we as a committee decide today, whether it's 69, 70, 71, whatever it is, does the number, does the percentage of students, does that increase? It stays the same? Or decrease, meaning overall, as opposed to just, the actual quantitative numbers?
Good question. And you mean in terms of the percent of students that pass? Yeah. So I mean, kind of illustrating that point, if you set a cut score, and I'll go a little wider range of say 68 to 72. If you make a final determination that 68 is the 68% correct is the cut score, a higher percent of students will pass that exam, pass the first year exam, than if you set it at 70 or if you set it at 72. Whatever you set it at, that is then the value that becomes anchored to 560 on the interpretive scale. But whatever that raw score recommendation that you recommend, that becomes the baseline against which we will then use as a reference going forward. Now, one of the things to I think also note is that because of that relationship that we talked about with the meaning the predictive relationship that Dr. Bolus had in his report, we know that about 70 is close to the point at which students passing this exam would have about a 50% probability of success. And so it's important to understand that a recommendation that then is below 70, the probability of success will be slightly lower. If you go above, the probability of success is slightly higher, because you're setting by changing that sort of predictive relationship. If I drop below that, I will now be slightly less. Now it's not horrible. I think my guess is probably like 48% or 48.5%. And if you go above to 71 or 72, that's probably like a 51 to 52%. So it's not a major shift, but it is something I think, again, given the purpose of the exam, what sort of policy expectation do you want to communicate to the stakeholder population to say, yep, here's where we set it, and here's what it means in terms of your likelihood of succeeding in the future, so that they can make an informed decision.
Do the test takers get their actual scores reported to them?
In terms of what it looks like when they pass or fail?
Well, I guess when they pass so do they know
Yeah.
if they barely passed, that maybe that would make them wonder a little more as opposed to, having a very high score? And in other words, it's just occurring to me that giving them that information is better than just giving them the pass-fail information. In terms, to the extent that they think hard about whether they should go forward, which may be an assumption on my part that's incorrect, but.
I think if someone passes, they're probably, I don't know. I have no idea the state of mind of someone who passes, but they're probably excited to pass
Could we
the
think
exam.
about maybe
In terms
making
of
that our practice?
the letter they get back informing
Yeah.
them that they're pass.
And maybe 10 years from now, we could also give them a link to the Dr. Bolus study, and offer that for their information if they choose to consider it.
From the policy perspective, I think my struggle here is I don't know if we're voting on a specific number today. Because we have three numbers based on the spectrum, 69, 70, and 71, or you can just go with that range. But from the policy perspective, it's a lot easier to start with a higher number and then go lower instead of just picking a low number, right? You can imagine if we go with a low number and somehow 80% of the students pass the first year. I mean, now at that point in time, you're going to have to come up with an excuse to heighten that score. I think you're going to get a lot of pushback, right? So I'm just having difficulties in terms of, am I deciding on a score, like specific number today?
Yeah, you have to decide on a raw score number today.
That's the problem, because I still don't understand the differences between 69, 70, and 71. Like, what is the predicted pass rates of those three numbers? I can look at the historical perspective, last 6 years, but as I said before, 2 of those 6 years are outliers data, and we don't have anything before 2018. And so now I'm just standing on one foot trying to guess which number makes the most sense. And that's not fair for applicants.
Do we get an answer to Paul's question about whether they either know they pass or fail or get an actual score number? What was the answer to that question?
They get the actual number.
So they know they got this score and that was barely above passing or whatever, currently?
Right,
Okay.
and I suppose we can give more information. There's no harm in giving them more information.
They do. So if you're successful or unsuccessful, regardless of what it is, you'll get your score, and then you'll also get your score by area.
And we have to pick a number today. That's where we are.
Right, in order to continue to, so the exam changed, and that's when you do a standard setting, and then to continue to have a raw score set, we need that for the next exam.
The exams already took place 2 months ago, June.
The June exam was the first one that changed to all multiple choice. And so once you have the data, that's when you do this study to set a new raw score.
And what are we changing it from? So what is it, if we did nothing today, if we passed this, what would it be? Or are we just stuck without exam results?
I don't know that, this is probably a question for Chad, but I don't know that we need to set a new raw score because the exam changed.
Yeah, if you were to, so if you were to just say, well, whatever the I won't say score, but the passing expectation was for the June 2023 exam, it would map to a 74 on this year's test. So that's what, where in the historical relationship there, where it says 2023, 13.7% pass rate, 74 would be the passing score. But again, as I think Alex mentioned, we don't know if there is some COVID effect or something else going on there that is mitigating that interpretation.
And Chad, I think there was some discussion about those being in combination with the essay scores as well, right? Was it
Correct.
particularly different, getting those scores out or separating them out from the written portion that would make those either not as accurate or not as indicative of where we should go?
Well, because the prior exam did have multiple choice and essay questions, there wasn't a passing score that only applied to the multiple choice. It was a compensatory score that used the combination of performance from both the multiple choice and the essays, with the essays being scaled using the multiple choice questions. So to kind of disentangle that, the only thing that we can do is to say, here was your passing expectation that has been, and again, in place for the last 20, 25 plus years. That passing expectation hasn't changed. So if you retain that passing expectation, the passing score this year would be 74 on just the multiple choice portion, 74% out of those 100.
I was just gonna say, I mean, the truth is, we're not gonna know, this is Renee, by the way, we're not gonna know the effect of this until, what, 2 years, right? Until these first-year law exam takers take their bar exam. So I guess when going back to Alex's question of not having a leg to stand on, I mean, it seems like if we do a lower cut score, pass scores rather, that gives more opportunity, and then we'll see what happens in the future. I guess that's the thing. If we do a pass score, and then that offers slightly more percentage, because we're talking numbers, right? It's really just what, like a few people. So, but if we're doing that, then I guess the point, I'm having a hard time articulating it, but I feel that my advocacy would be for a lower cut score, a lower pass score rather. And try and see what happens, because this is, we got rid of the essay for the first year law exam because it wasn't a good predictor that was of passing. It wasn't helpful, and the multiple choice was better. I think the bar exam has the essay portion. We'll see what this does, but it would seem to me that having a lower pass score would just afford a little bit more opportunity. So I don't know, Alex, I guess I'm trying to push it back to you in terms of trying to understand your comment of saying setting it higher would be better, because then we'd have to address it and going lower. And so I guess I'm trying to have that
I think
conversation.
just my concern from the applicant's perspective is if we start low and somehow, we open the gate and we allow a lot more applicants passing the first year, even though they're not really that knowledgeable about certain topics, well, we open the floodgate, right? Then at that point in time, are we going to then suggest, well, let's heighten the pass score? It's a lot higher to try to convince the public. We need to increase and up the cut score than lowering it. I think that's really the concern from the policy perspective. How would you explain and convince the public we need to heighten the cut score when the Supreme Court is trying to lower the cut score? Does that make sense?
Yeah, but I mean, they have that information. That's why I think it's a good question by Paul as to, what their actual score is, and how that correlates to their chances of passing, which, again, we're not going to know yet for another couple of years. But I hear what you're saying.
Yeah, I think we're in a position where we have to make some kind of decision, and perhaps going down a point or two, I think I'd be willing to go down to 69, it's not going to create a great change in the prospects for people who pass the first year. A few percentage points, maybe less will be their predicted success on the bar exam. And then we may have to adjust in the future. People, I think Jim appears to definitely feel that, we should not foreclose opportunities for people. And I'm sympathetic to that as long as they know what they're looking at. Although I also realize that a lot of people, well, take Garrison Keillor's Lake Wobegon, everyone's above average, and we know that's mathematically impossible. And everyone will also assume that I'm the one who's going to make it through. So they'll probably blow through a stop sign. But all we can do sometimes is make sure the sign is there and somebody hasn't knocked it down.
Are there any other comments? Well, first, are there any other questions for Dr. Buckenthal from the CBE members? Okay, seeing none, are there, like to open it up for more discussion or comments between us as the CBE to kind of decide in what direction we want to go? I mean, there's a policy issue, there's a numerical number that we have to come up with today. Like to see if there's any other thoughts from our CBE on this.
I have one other concern, I guess, is if you look at this the other way, 70% of the students fail this exam. And are we doing something wrong that 70% are failing, that are somehow getting into law school and still can't pass this exam? Just leave that out for comment. That's not for today to resolve. But 70% is a pretty big failure rate.
Well, and it occurs to me, the answer to my previous question, one of the other purposes of this exam, I suppose, is to assess the job that the law schools are doing. So if this is predictive of the likelihood of bar success, and we believe, as I do, that the goal of law school is not just to give somebody a JD, but give them the ability, if they choose, so to pass a bar exam and become a working lawyer. This is also a test or a check on the law schools, their performance.
But also just to remind ourselves, as far as who the baby bar targets, and the rule is pretty clear, only those law students completing the first year law study, right, in an unaccredited law school or through the law office study program, or those without 2 years of college, work attending a California accredited or ABA accredited schools. And so we're talking about really specific subsets of applicants who have never, gone to accredited schools, who are just maybe working, in the day job and trying to study law at night, or just working at a law office. And so these applicants have no formal legal education. And so I think from that perspective, I think it is reasonable and certainly logical to expect the pass rate to be lower for these specific sets of applicants. But that being said, I think Jim hits a point. We need to think about, are we doing something wrong, or is it the schools are not investing enough of resources onto the kids? And this is the reason why we talked about it in the last couple of meetings. We need these unaccredited schools to move towards, or to advance towards, the accredited status, because that really pushes them, or the way I would say is to encourage or incentivize them to do something more instead of just collecting tuition and not doing anything for the kids, right? We have shut down how many schools now in the last couple of years? Anyone counted? Anyone? Quite a few. Either ceased operation on their own, or we just gave them notice of suspended the schools. I mean, I would say we have quite a few, right?
That either close voluntarily or, yeah. I mean, I'm not sure exactly the number. Natalie's.
Anyone?
So there's been one that has shut down, but there are a larger number voluntarily, but for a number of reasons: increased competition, death of the owner, retirement of the owners.
Yeah,
range
so
of
there's
things.
been more closures. And that's why the pool of takers is lower than it. I mean, even, I think maybe 4 or 5 years ago, there used to be 500 or more than 500 taking the exam, and now we have around 200, 230. So the pool is smaller, law office study and unaccredited students taking the exam. So, and that could affect the pass rate.
So time will tell, I guess. In 2 years, we will revisit the success of whatever we decide today. But I'm also concerned. I'm pro Jim. I think we need to think about how that would impact the rates.
And maybe I can jump in here as well. just because we had, I think, a pretty hefty discussion about that as well during the process. I'm in agreement with Jim. I think that we have to have some level of faith in our outline policies and procedures and ensuring that these schools are meeting certain restrictions to ensure that their students are prepared. And if we believe in those processes and procedures, then I think we have to necessarily believe that there's something wrong with the test itself. And that was raised, I think, like during the process, that there were questions that were too vague, too confusing, not clear. And I think the statistics, and Chad can speak, I think, to that as well, but we talked about how it would offset, right? That the particularly confusing or very difficult exam questions would still kind of, in the grand scheme of things, even out against the ones that were more straightforward, easier, so that we have this generalized number. But I think a good portion of the attendees that were on this panel, I guess it's panel, we're also speaking to the fact that, there were issues with the makeup of the exam questions in and of themselves. And so I think that longer term, we also have to have, I think, a deeper understanding of whether that's true, whether there are these issues with the underlying questions, or if, at the end of the day, the statistics will even out that kind of error or any kind of perceived error with the questions. Chad, do you know where I'm going with that?
Yeah, you mean the last comment regarding just the kind of the sampling of content as well as the quality of questions? Yeah, and that's when I mentioned earlier that by removing certain questions out of those 10 that were kind of like experimental or pre-test, it actually improved the reliability early on or overall, meaning the 90 questions that are scored have a higher reliability than the 100 questions that were given because of some of the negatively influencing statistics for a handful of those 10 questions.
Thank you. So the way the staff has put out a motion, and then I guess the question is for us, do we agree with the raw score that the motion is put on, the raw score motion of 70, or do we feel that it should be changed? And if it should be changed, will someone kind of make a comment on that and what it should be? I know Jim had made his point articulated right up front, and see if there's anyone that will second your motion, or not your motion, but your idea.
Well, I think it's time to make a motion, and so if that's permitted, if you can put the recommended motion up there, I'll modify it to how I believe the motion should be made. If that's possible.
We'll put that motion up.
I think it's on page 3 of 4.1. I don't know if anybody can read it there.
Can you enlarge that? I don't think we can see that.
Make it full screen with.
Okay. So you want me to read it? I'll read it. I'm going to change the 70 to 69. Resolve that the Committee of Bar Examiners adopt the panel recommendation, actually modify the panel recommendation to a raw score of 69 out of 100 on the first year law school exams, FYLSX, as the minimum score to pass the exam applied to all FYLSX exams beginning with the June 2024 administration.
So the motion has been modified by Jim and second by Paul Kramer.
adopts and modifies.
Instead of recommendation of, recommendation to would work.
I just said modifies the panel's recommendation, take the adoption. Take the adoption.
we need the word adopts
How about adopts and modifies?
Bridget, do you want to use a microphone?
How about adopts as modified?
Yeah.
Well, do we even need to speak to the panel at this point, because it's our decision? What if we just say we adopt a raw score of 69?
Friendly amendment.
Yeah.
So this doesn't come into play until, what, 2 years from today?
Well, no, this is for the June exam.
Right, retrospect, right.
Yeah.
So if I may, Jim, I just want to add at the very end of that sentence, with the CBE revisiting the results of this recommendation within the next year or two, or something to that effect, just so that the CBE is aware that we have to come back and check the success rates of whatever the outcome is with respect to this motion.
I'm okay with that, but we won't have the bolus data type for like 4 years.
4 years?
You know,
But I think, but just looking at the results for the next year or two, I think.
Pass rates will know, yeah.
Yeah, at least looking at the pass rate to see whether we need to make the further adjustments. So I think that the friendly amendment that I have is with the CBE revisiting the success or the outcome of this motion within the next year. Would that be okay?
I think it's, yeah, it's a good idea, so yes.
Yeah, I'm okay with it.
So maybe that's a further resolved.
Bethany, you have a comment?
I do. I agree with you in principle, Alex, that, you know, we should have some kind of trigger to review. A year just seems very soon. And what if there's a situation where, you know, the pass rates or the percentage of pass rate goes up, but then we do find out in 4 years that we're still holding a 50% bar passage rate, you know? And so I don't know, I feel like it might be beneficial to wait the 4 years until we have these first round of people actually taking the bar to kind of reevaluate, because I don't know if like August of next year, if it's going to be particularly useful just to have 2 more first year law exam results, but I don't know, that's just my thoughts.
I agree with what Bethany said. I agree too. I don't know, if we come here next year, what results are we gonna have? I mean.
We can see if more people are passing the first year. We won't have a predictive result.
Right.
So 4 years then. I'm okay with
And
that.
even that will have maybe just one administration of the bar exam,
Yeah.
so it'll be.
I just want to make sure we have some record that, well, whatever we decide today is giving notice to the future meeting that we have to come back and visit. This is not a one-time thing where we just overlook it 4 years later. So 4 years is okay. I think that's reasonable. So instead of 1 year, let's just put 4 years.
Okay.
Or we could just add it to the work plan to monitor.
That's right, yeah, that is a good point. So work that into the annual work plan.
Bring that back the next meeting.
Good point. Yeah. So 2028. Thank you, ladies.
Could we have someone read that who's closer to the screen than me?
Yes, I just think Paul had a recommendation to take out the panel recommendation. You had that edit, Paul. Do you want that before
So
we
just
read?
say adopts a raw score of 69.
Yeah.
Are there any other suggestions or friendly amendments for the current motion on the screen? So, Devin, would you like to do a roll call vote?
Again, can we have someone read it? Because I can't read it from here.
Oh,
I'm sorry.
okay, I'll read it. So it says that the Committee of Bar Examiners adopts a raw score of 69 out of 100 on the first year law students exam as the minimum score to pass the exam applied to all FYLSX exams beginning with the June 2024 administration. And that further resolved that the committee will revisit the success or the outcome of this motion within the next 4 years by 2028. Does that sound okay, Jim? Yes. Paul, is that okay with?
Yep, it's okay.
All right, let's take a roll call vote.
Dr. Bolton?
Yes.
Robert Brody? Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora? Larry Kaplan?
Yes.
Paul Kramer?
Yes.
Alex Lawrence?
Yes.
Esther Lynn?
Yes.
Justice Macy Walla?
Yes.
Bethany Peak? Ashley Silva Guzman?
Yes.
Judge Reyna?
Yes.
Vince Reyes? Alan Yokelson?
Yes.
Dr. Cow?
Yes.
With 13 yeses and 0 nos, the motion passes.
All right. Moving on to agenda item 4.2, I just want to make an announcement that due to an administrative error with the posting of the materials for this item, we are withdrawing the item today, and we will reschedule this for a future meeting. So then we will go on to agenda item 4.3, action on the 2024 minimum cumulative 5-year bar pass exam, 5-year bar exam pass rate compliance reporting for accredited law schools. I'll turn it over to Natalie.
Sure. Paul, did you want to make any comments before I put up the motion?
No, go ahead.
Okay, so Tara, if you wouldn't mind from the motion document, just placing up the motion for the NPR item. And in the meantime, I'll just remind everyone that California accredited law schools are required to report a minimum cumulative 5-year bar exam pass rate every year. They've been doing so continuously since 2018. It's based on 5 years of data. This year, that would be graduates from August 1st, 2018 through July 31st, 2023. Only those who choose to take a bar exam. There's also an allowance in that item for those that licensed through the expanded pathway of the provisional licensure program. This is a minimum requirement that they must meet every year. It's very exciting to show you the very simple motion accepting those reports from all 15 reporting accredited law schools who met that standard this year. But before we pass the motion, I thought it would be helpful to share a couple of terrific facts. The first one is that you've set a threshold of 45 as a letter, a point in which you give a warning letter. This year, there are no warning letters to give. Every school is above that level. 11 of the 15 reporting schools are now increasing their score versus last year, and 7 are reporting over the 70. So it appears that they truly see this number as you intend it, a minimum floor rather than a target. So in the materials, you can see a chart with the scores for each school, but you also see a line graph showing that since the introduction continuously in 2018, the numbers continue to grow. And I think that that's terrific to hear. We have several of the deans here in the audience for public comment, and it's so nice to share this in their presence and also for those that are watching through the Zoom link. Are there any questions? Okay, is there anyone who would like to entertain a motion?
I'll make the motion if no one else does. That's fine. Jim Efting.
And I'll second that.
All right, Devin.
Dr. Bolton?
Yes.
Robert Brody? Alex Chan?
Yes.
Jim Efting?
Yes.
Kareem Gangora? Larry Kaplan?
Yes.
Paul Kramer?
Yes.
Alex Lawrence?
Yes.
Esther Lynn?
Yes.
Justice Macy Walla?
Yes.
Bethany Peak? Ashley Silva Guzman?
Yes.
Judge Reyna?
Yes.
Vince Reyes? Alan Yokelson,
Yes.
Dr. Cow.
Yes.
With 12 yeses and 0 nos, the motion passes.
Thank you, Devin. So we have a special set at 11 a.m., which is in closed session. It's about 10:50 right now. I'm just going to call for a break for 10 minutes, and then we can all reconvene back in closed session for the special set. Thank you. All right, so we will do a roll call vote for the open session.
Jean, just to confirm, we need to do a roll call.
Please go ahead. Go ahead.
Okay. Dr. Bolton?
Yeah.
Robert Brody?
Here.
Dr. Cow?
Yes.
Alex Chan?
Yes.
Jim Efting?
Here.
Kareem Gangora? Larry Kaplan?
Here.
Paul Kramer?
Here.
Alex Lawrence?
Here.
Esther Lynn? Justice Misiwala?
Here.
Bethany Peak? Ashley Silva Guzman? Judge Reyna?
Here. Here.
Vince Reyes? Alan Yokelson?
Here.
We have a quorum.
Thank you, Devin. So where we left off on open session was agenda item 4.4, discussion of unaccredited law schools, proposed revisions and next steps. I'm going to turn it over to Natalie.
Thank you, Dr. Cow. So many of you may remember that the committee made a recommendation to the Board of Trustees that adopted new unaccredited law school rules fully implemented this year. And overall, the admissions office has been going through all of its rules to update them. And it's now the time to review the unaccredited law school rules. Leading up to this, we've had a number of discussions, a number of opinions. You've heard about data from the law school performance report and the law school profile. You've discussed several options to address current performance at unaccredited law schools. A longer-term option could be potentially mandatory accreditation, but the committee here discussed several proposals and possible rules revisions that could be implemented more quickly in order to provide support and improve the outcomes at unaccredited law schools. So I wanted to ask Tara to put up the PowerPoint so that we can talk a little bit about what's been put together. I'd like to particularly recognize your contacts, Alan Yokelson and Paul Kramer, who have agreed to be the contacts in reviewing not only the data that you've seen, but additional data that we'll be bringing to you, and helping to create this rule set after looking at those data points and also receiving feedback from other stakeholders, including COAF and CS BARS, and there'll be more to come certainly from both of those groups going forward. We started the process with CS BARS last year, asking for general suggestions, and along the way, as there have been discussion points here at the CBE, we've been following on to the next meeting at CS BARS to discuss. So just this week, CS BARS discussed the priority list that you talked about in June. They were prepared to know that this discussion was coming today, and they identified 2 contacts that we'll reach out to just after this meeting to provide further support to the committee as you go forward. There is no motion associated with this today. This is merely an opportunity to introduce the rule set that is based on the priorities that you previously identified. So we focused on a number of areas. The first one is technical revisions, and those are based around areas where we've gotten questions from schools or from you. In particular, just coming up with a common nomenclature to call unaccredited law schools and make it clear that that's a status that a school must earn. So using a consistent term of registered unaccredited will make that more clear to the public and prospective students. Also just consolidating our definitions and making a clear distinction between what belongs in a rule and what belongs in a guideline providing additional details as to how to implement the rule. Next slide. Okay. We also looked to the learnings from the discussions around the accredited rules to add some elements that, that draw from our learnings at that time. So COVID taught us all that there need to be very clear emergency policies and waiver possibilities. The committee was able to successfully respond to COVID in this instance, and having clear guidelines will help in the future should something unexpected come forward. We're doing inspection process changes. We've now pretty successfully been doing our inspections in a remote format, and we're updating our forms to match the new rules in the accredited area, the jointly status, which released in July, and we will be updating our unaccredited materials to match any changes that are created here. We also have tried to streamline the rules related to probationary periods and termination of registration to more closely match what the accredited schools offer as well. There was a double process related to inspections and then the non-compliance process. So this is additional time and additional effort from schools. We now can make all of the options very clear to the school up front and proceed in a manner that still provides all of the due process they're used to receiving, but can also allow the CBE to take efficient action when needed. Next slide. We'll also be making revisions to existing language to modernize the rules. For example, improving consumer disclosures. When these rules were written, they were actually written pre-internet. And so disclosures were changed once a year. But now, as a practical matter, they can be changed more often. New scores, new results, new changes can be incorporated. And ways of distributing the disclosures have also changed. So the new rules are proposed to reflect that. Also, a way to provide consistent financial information was needed, as we now see many more entity types in this space with many more entity statuses. So having a clear way for prospective students to know the financial health of their school is important, and we're trying to do that here. We also are wanting to expand the complaint process to make sure that every school has and can document to the State Bar a third-party complaint process in the case of students having a complaint. And we're clarifying the major change requirements, in particular around the word division. We're asking unaccredited schools to provide notice to the committee and staff when they change schedules, add tracks, et cetera. The idea behind this is not to be too involved in the day-to-day processes of the schools, but this is an area where it is very important that they hew to the requirements of Business and Professions Code 6060. So by making this clear and having this review before the various tracks are implemented, we believe that we can prevent problems and advantage students over the current process. Next slide. We also, a very different part of this proposal is an option where we'll be seeking a particular area of feedback, which is modernizing the law school categories. Right now, we have a fixed facility option, and we also have a correspondence option that's been discussed in the rules as a correspondence and a distance option. So getting back to the time when these rules were written, the internet was relatively new, and so it was dividing It was dividing pedagogical teaching between I receive a box in the mail versus there is interaction. But now we have quite a bit of interaction online. In fact, we have it right now here at the CBE meeting. And so these rules we think will better align with the two categories of 6060, making categories of asynchronous teaching and synchronous teaching. So we're looking forward to feedback regarding that. Next slide. This is just a little bit of a flow chart for folks that would prefer to see it this way. I'll take a moment to pause here. Does anyone have any questions about this idea in general? And I'm no surprised because it is actually drawn from some feedback and discussion here, and then also through Paul and Alan. Next slide. A new proposal that's contained in this package that we're sharing with you is a binding minimum pass rate requirement for unaccredited law schools. For some time now, unaccredited law schools have asked for the NPR formula, rather than their current cumulative formula, to be used on their disclosures so that it would be a straight comparison between the accredited and unaccredited schools. And also, many of the unaccredited schools have the interest to become accredited at some point. We will be already changing the annual reports to incorporate that this year. And we would like to discuss making a binding pass rate here as a consumer protection element for students. Next slide. That's been very helpful in the area of the accredited schools. We talked about it a little bit earlier. It was such a pleasure to report to you that your work has resulted in 11 schools increasing their scores this year, and 7 schools versus 3 when we started, having pass rates over 70 points. So that's 30 points above what their minimum is. And we hope that that same type of success can be replicated at an appropriate level in the unaccredited schools category. We've attached the full proposal as an attachment on the agenda item, and we'll be sharing it with the CS bars, also with COAF, and just generally with other stakeholders as we go forward. And it's our intention to bring back to you this proposal, plus modified by any feedback we receive for your consideration and potential recommendation to the Board of Trustees. Are there any questions or comments?
Natalie, just one note.
Yeah.
We didn't mention in this attrition rates, but that's another avenue we may look at. When you have a school where a majority of their first-year students don't make it to the second year, that at least it's worth asking ourselves if that is an indication of some sort of problem that we need to monitor. And there may be a few. We had in the recent past, you alluded to a couple of big major questions we presented to the committee, and the committee decided to look further on all those. So to the extent they're not reflected in this list, in this draft, they may also appear in the next draft that would be brought back to the committee for and presented to the stakeholders for discussion.
That's a very good point, and we will also be able to bring back to you some anecdotal data from the inspections that we've been doing as well, because we've been having in-depth discussions with the schools when there is a large attrition rate between year 1 and year 2. We've been talking with each school individually about the options to adjust communication, admissions policy, academic support, curriculum, and other factors that we may not yet have plumbed to see what options could be available to continue to improve retention and persistence for students.
Oh, another topic that would be on that list would be the admission standards to the law school. For instance, I think the idea was floated that maybe there should be some use of standardized tests in the admissions process. It's, again, it's to be discussed, but that's another topic that may surface.
Yes, absolutely. And that could include a discussion of JD Next, the new sort of hybrid class and exam product that some of the ABA schools currently have a variance to use. That can be particularly interesting now because I think we'll see this fall that there will be a rapid and large expansion of the number of online programs available to ABA schools. So at this time, having an admission score like that, which an ABA school will require, could give students a more clear picture of their possibility to attend any of the 3 types of schools. Rather than simply an accredited or an unaccredited, and then they can determine which of these categories is right for them. Mm-hmm. Yeah, are there any other questions? Okay, seeing no further, we'll get back to work and look forward to bringing you an update at a future meeting.
Thank you so much, Natalie, for that presentation. We will move on to agenda item number 5, which is the director's report. I'm going to turn it over to Audrey.
Thank you. The first person up on our slide deck, thanks Tara, would be Becky Romero.
Thank you, Audrey. Good afternoon, everyone. I wanted to give you a quick update in regards to the June 2024 first-year law student exam, which was administered on June 25th. It was an in-person administration at Prometric Test Center sites. So applicants that were unable to test at a Prometric Test Center site did test remotely. And some of the reasons of why they cannot test at a Prometric site would be because they just don't have a facility that's close to them or because they live out of state. So this was the first examination where it was an all multiple choice exam. There was 100 multiple choice questions divided into 2 90-minute sessions with a 20-minute break between each session. And we expect for the results to be posted on the applicant portal on August 30th at 6 p.m. And next slide, please. This gives us a count of the applicants that we had testing for the June 2024 first year. So at a Prometric Test Center site, we had 174 applicants. 4 did not show. Applicants that were testing remotely, though that was a total of 68 applicants, 4 no-shows as well. So we had a total of 242 who attended and 8 applicants that did not show up. As you can see from these numbers, most of the applicants tested using a laptop. We had 169 using a laptop. We had 5 writers. And applicants that tested remotely, we had 68 who actually participated and 4 no-shows. Next slide, please. And now I'd like to give you some preliminary numbers of what took place at the July 2024 bar exam. These are just preliminary numbers. We're still gathering information. And we expect to, thank you, Adrian. And we expect to have more information for you in September. So the July 2024 bar exam was administered on July 30th and 31st. It was an in-person administration, and it was administered at 16 different test center sites. We did have some new locations, which were composed of the Golden Gate University, the University of San Diego School of Law, the Chula Vista Athlete Training Center, and the grounds in Roseville. We do expect for the results to be released on November 8th at 6 p.m. And like I mentioned, we are still composing some information, and we'll have more information to follow in the September meeting. So this is just to give you an idea of how many applicants we had testing. As you can see, most of them were laptop applicants. We did have a couple of applicants that were granted testing. Oh, if I could have the next slide. Thank you. With testing accommodations, we had 3 applicants who used a computer with screen reading software, 8 who dictated to software. 6 that dictated to typists. We had 8,289 applicants that used a laptop, and we had 312 applicants who wrote the examination. And we also have a breakdown of applicants that attended by facility. If I could have the next slide, please. This will just give you an idea of where we had most of our applicants. Just wanted to mention that some of these numbers, for example, at Pasadena, we did have 3 locations. We had L102, who was composed of just laptop applicants. We had LW112, who that test center site was composed of laptop and writers. And we also had S202, that was a test site for testing accommodation applicants. At Ontario, we also had 3 locations this time around, which was composed of L400, which was only for laptop applicants, LW402 for laptop and writers, and we had S400 for testing accommodation applicant. And Oakland this time around had 2 test center sites. One was composed of laptop applicants, and the other one was for testing accommodation applicants. So as you could see, these numbers were composed of a lot of applicants, and this time we used a few facilities that cater to 2 different types of test center locations, and at sometimes 3. Next slide, please.
Question.
Yes.
Am I reading that slide? Go back to that slide before. Am I reading this correctly? It looks like, to me, there are a lot more applicants taking the bar exam in Northern California by several fold, excuse me, in Southern California than Northern California.
That is correct. And what it seems this time around, because we're still gathering all the information, we don't have a breakdown specifically for like Pasadena and Ontario and Oakland. So we kind of bolt them all together. And when we meet in September, we'll have more accurate numbers. But this is just to give you an indication of what you have to come around next month.
That's a useful data point. It only means we probably have to put more resources into getting physical locations for the Southern California folks than Northern California.
Right. And are there any other questions? Okay. So we could go, yes.
Did we get any comments about the Chula Vista location? We have some law clerks in our office who said that it was very warm there and to the point of being uncomfortable. Did we hear anything about that?
I'm in the process of reading some of the facility reports and actually some correspondence from applicants. And I have not seen any complaints in regards to the weather or it being too hot or that sort of thing, not yet. So
Okay.
if I do, I'll make sure to mention it in September.
Thank you.
You're welcome. And the next slide will just show, as you can see, most of our applicants are taking the examination by laptop. So the majority of people testing used a laptop. So other than that, that's all I have to report for now. More information to follow very soon. Thank you.
Yeah, it's not a question, but I just wanted to, I did get to visit a testing center, and I wanted to share some feedback I received while I was there, if that's okay? Thank you. So I did go to the Ontario Center, and I'm shocked that it was the populated center, it seems like, because people there apparently really liked being at the Ontario testing site. I took a nice tour. I got to see Tara and David. They were there. And so I got to observe both of the rooms, but specifically for testing accommodations, which was upstairs. 2 separate people unrelated told me that Ontario was their favorite site for testing accommodations specifically because since it's not a hotel room, they're able to group more testing accommodation students together. And so the woman I was speaking to, who I guess was in charge of testing accommodations, she was saying when she's at hotels, you know, they need 1 proctor for each applicant in a room. And she's like, it's super stressful. Like if I have 150 testing accommodations, that means I need 150 proctors. Mm-hmm. And she likes Ontario because they have the larger rooms. And so most of the testing accommodations applicants were in groups of like 10 to no more than 14 per room. And so I got to look at several of those, and, you know, it was a nice setup. They had ample space, like 5 applicants on one side, 5 on the other. But she said that that extremely alleviates the stress that they feel, because she only needs, you know, 2 proctors for 14 people now. And that dramatically reduces, I think, their own internal stress. I know when they're short on proctors, the bar provides them, because they were short the day that I came, and they said the state bar had already sent over like 20 more. But it was something that 2 different people mentioned to me, and so I just wanted to come and bring my feedback and share that with the group.
This is Robbie. I guess I want to echo a little bit of what Bethany said. And, you know, for all CBBE members, I think Becky is, my hat is off to her, because she's just picked this gargantuan task up. And I visited the Pasadena site, and CBE members, you can take great pride in how this agency administers the bar exam. That I just can't say enough. Pasadena had 1,300 applicants in 3 spaces. I mean, it was just overwhelming to see how our staff pulls it together. We had accommodated applicants in Pasadena for the first time, and like Bethany, I got to see these sort of minimal distraction rooms with 20 applicants, and you know, they're pretty impressive. I did not know, and Bethany, I don't know if they did that in Ontario, but we provide shields that look like the kind of things that go when your car windshield, so the sun doesn't go down. So even in a reduced distraction room, you can kind of close yourself off if that's what you feel that you need, and they were in use here. But in the bigger rooms, again, to Elvia, who managed the Pasadena location, the first day is for training of the proctors. I think they had 25 no-shows. So they had to scramble. If they don't have the proctors, they can't open the doors. They can't do it. Somehow, I think working with Audrey and Becky, they got it together with a staffing agency. Just very impressive. And I know as we move today towards alternative methods of administering the bar exam, there is something to be said for the gravitas and the integrity that we give to the exam when we administer it in person. And if that was the last time and I got to see it, well, everybody in this room should take great pride in how we do it, because it was just so impressive. And I don't think there was even one Chapter 6 in the Pasadena location over those days. And that's thanks to the staff, right? You got your eyes out, who forgot they have their phone, 1,300 people in and out. And I'm going to say one more thing. I know we're not doing in person anymore, but the best move we ever made, which I think, Audrey, was under you, was permitting liquids at your seat, reduced almost all movement. In the old days, there was so much getting up and I admit it was distracting, but I'll tell you, with a water bottle at your floor by your side, there was almost none of that. It was just a very, as comfortable as it's going to be to take the bar exam, and everybody here deserves thanks from the public and applicants, because I was just so I was just dumbstruck. And I know I emailed you, Audrey, and Becky. I didn't have your email, but I'm going to forward that to you. But many thanks to everybody in the bar for pulling that together. It was just an impressive administration of the bar.
Thanks for saying that. And I would just add, this was Becky's first exam as the program manager. It was a large July exam, and she did a wonderful job, and there were very few incidents.
Anyone observe the Oakland Convention Center? I always wanted to hear some comments.
I did. None of the committee members were there, but
No one?
yeah, it's another very large site. I think that Maria is next.
Yes, I hope everyone can hear me okay.
Do you mind introducing yourself, Maria? I don't know if they've heard you.
I have not. Yes, I'm a program analyst here in the Office of Admissions. I work with testing, accommodations, and data and policy. And I'm going to go over some June first-year law student exam survey findings and then a little bit about the July exam. But for June, first of all, the Office of Admissions want to give appreciation and thanks to the Mission Advancement and Accountability Division, which has worked with admissions to develop a more effective post-exam survey. And this is our first using the newly adopted best practices. This is also the first survey of test takers after several new policies were introduced to the first-year law students exam. So firstly, the exam was administered at Prometric centers statewide with a remote option for those with extenuating circumstances available. An example would be an applicant who lives significantly far distance from a Prometric testing center. So this visualization shows responses to the question, overall, how satisfied were you with your experience for those who tested both at the test center or remotely? And our survey revealed that 84% of respondents were satisfied or very satisfied with their test center experience. Although fewer felt the same about the remote exam, less than 2 in 10 were dissatisfied. So these are promising results, and they do support our ongoing efforts to integrate remote and live proctored exams with test center components, maybe including for future exams. The next slide, please.
Were they using
Beyond
the same
overall
software?
satisfaction, the survey showed a positive sentiment towards various aspects of the exam experience. Most respondents agreed that the test center staff were professional, it was easy to secure a test center seat, and that transportation to the test center was easy. This feedback, of course, is crucial as we consider incorporating test center components for future exams. Regarding the remote exams, a majority found it easy to locate a distraction-free space, and the majority found it easy to find a space that met the environment scan requirements. 2/3 of respondents were comfortable with the environment scan process. This suggests that while some applicants may lack an appropriate space for remote exams, the issue is not widespread, and a test center component can be one convenient way to accommodate those needs. Next slide, please. The second,
Maria, I think there was a
I'm sorry,
question.
sure.
Yeah,
Sorry.
so between the test centers and the remote exams, were they using the same testing software?
Yes.
So that's not a variable then. Okay, thanks.
Thank you. Let's see. Oh, right. The second major change this year was the shift to an all multiple choice exam. Our survey indicates that nearly 3/4 of test takers felt more prepared for the all multiple choice format, with less than 10% feeling less prepared without that essay component. This is positive feedback, and it's particularly significant as this cohort is the first to experience the new exam design. And of course, these are preliminary findings, and we're eager to further analyze the survey data and bring additional findings forward very soon. Next slide, please. Turning to the July 2024 bar exam, as Becky reported, it is a significant increase in the number of test takers with 8,627 total, the highest since the pandemic. This visualization shows that there has been 3 straight years of test taker increases. A second y-axis shows year-over-year percentage changes, highlighting a notable increase in October 2020 due to the pandemic, followed by 2 years of declines, and then a modest increase in July of 23. The trend continues with more substantial increase from 23 to 24. Next slide. Finally, we analyzed the number of approved and partially approved testing accommodations by each administration. This visualization shows that after a sharp increase in October 2020, we saw a correction in 2021. And since then, there has been steady growth in accommodation approvals with 7% increase from 21 to 22, 21% increase from 22 to 23, and of course the 18% increase. The growing rate of change may be partly attributed to the growing number of applicants as a whole taking the exam, as well as new admissions procedures aimed at simplifying the process and applying for testing accommodations. Thank you.
Any other questions for Maria? I think that's a seamless transition to you, Christina.
So earlier this year, we took some significant steps for updating our website and our communications. about our enhanced testing accommodation process. This did include introducing the automatic approval process, which has already begun to streamline the process and the experience for applicants. Earlier this morning, we reached another important milestone, and that was the release of our new testing accommodations application in our applicant portal. The new application has several features, including the reduced need for documentation. Those with multiple disabilities no longer have to have their qualified professional fill out multiple forms and submit to us. We've also worked on clarifying typical testing accommodations, typical testing conditions and standard accommodations approved by the State Bar. And along with this, we've also provided detailed instructions to help applicants and their qualified professionals better understand exactly what the State Bar requires. These changes, we hope, are going to guide the applicants and their professionals through the application process with a greater ease, minimize confusion, and hopefully ensure more accurate submissions. We're very excited. This was a long time coming with the application being released in the portal, so very excited.
Any questions for Christina? Okay. Usually Amy does this, but she's not here, so I will talk a little bit about the bar exam experiment. So just to refresh, we've been working with a grant from Access Lex to experiment on some features that could possibly change with the future of the bar exam. Things that were tested in this small pilot we did in October 23, we want to continue testing through phase 1 and phase 2 from this fall to next year, testing things like remote and in-person, open book versus closed book, and then some modifications on timing, the standard timing we might give for an essay or extended time. So those are still the variables we want to test, but we have some new timing that we're going to look to change how we described in the past to you the full experiment. So the full experiment proposed now will be doing a phase 1 at the very beginning of November, part of the experiment then, and then a phase 2 in 2025. The Committee of Bar Examiners today in closed session also discussed the bar exam experiment, and they are recommending to the Supreme Court that there be a scoring adjustment tied to incentivize participation in the experiment, and also recommending to us to reach out to Access Lex, the funder again, to see if we can also give participants a financial incentive. Okay. Stop me if there's a question for me. So update on the vendor for the February 2025 exam. This week you might have seen we had a press release around the fact that on August 9th, our board chair and Kaplan did sign an agreement for them to produce the bar exam multiple choice questions in time for the February 2025 exam and beyond. So on July 18th, the board met and approved for the board chair to finalize that contract agreement, and that has moved forward. There's a lot of communication and planning that needs to happen from the Office of Admissions to all the bar exam applicants in 2025, and that will be underway with a lot more updates that you can anticipate from us about how we were going to pivot to a new style of exam, and some expectations around what the questions will be like. Part of what you can expect are, we're going to provide free study guides for students and free faculty guides for law schools, just so everyone can see the style of the multiple choice questions. And I know there's going to be lots of questions around this, and we're going to do a lot more outreach to stakeholders to make sure everyone's comfortable about the changes, but that is what has happened since the July board meeting. Yes.
Audrey, you mentioned multiple choice questions.
Mm-hmm.
Press release also mentions essay questions and performance tests, which is very new to me.
Oh.
I don't recall that ever being discussed as an element of the contract with the vendor. Are they, for the moment, only developing the multiple choice questions?
Correct.
So the EDGE team is still going to be involved in developing the essay and performance questions?
Well, and the Edge team now, they don't draft the initial questions, right? So the plan would never be for the Edge team not to be involved. The Edge team takes drafted questions and meets and improves them and gets them ready for the item bank. And so if and when Kaplan does that drafting, the Edge team would still be involved in all the rewriting, editing, and additions to the bank.
Okay, and then they're still grading as well?
Yes.
Okay, thanks.
Any other questions for me? So my recent development slide is blank, but I will say, I will say that this is actually the final meeting of this CBE calendar year. So the Committee of Bar Examiners has a calendar that starts with the October meeting and ends with the August meeting, which means that our current chair, Dr. Michael Cow, and vice chair, Alex Chan, this is their final meeting in these positions, not their final meetings on the committee, but I just want to say that it's been a really productive and interesting Committee of Bar Examiners year. I think we started the year wanting to do a lot of high-level policy making discussions, and I think that's really carried through, and I really want to thank you for your leadership.
And I'd like to say that this has been an unbelievable year to have Alex as the vice chair and everyone here on the board as well as the staff. This is it's a huge honor to lead such an incredible team who are all leaders themselves. And so I'm really thankful and honored to be able to be the guide for our committee for the last year. Thank you.
Thank you for your leadership. I don't think we could have a better year without your leadership, so thank you again. And then the staff, obviously, without overpraising them, and we all know they're very diligent and very ambitious in terms of just advancing the agenda items. And so thank you for your help. I think everyone here would agree, without them, we wouldn't be able to do what we do. I mean, period. So I know a lot of you are behind-the-scene people, but you're not forgotten, and certainly not in my book.
Thank you. I believe the next meeting is October 11th. It will be a primarily remote meeting with some of the members do choose to come in person to the office, but that'll be
Do we
nice.
know who the next chair is?
So I wish that I could conclude this by saying that, but we do not have that information. But stay tuned. In October, we will have a new chair and vice chair and likely at least one new member.
All right, so this concludes the open session for our meeting today. We're going to go ahead and leave the open session, and we are going to go back to closed session to finish the remainder of our closed session items. Thank you.
Hello.
Hey,
Hey, how are you?
good. How are you?
Good, good. I'm doing well. Hey, before I forget, let me know how much if your friend's able to get the ticket.
the closed session. And now I'd like to see if there's any comments or questions from my fellow committee members. Seeing, hearing none, the closed session is now done, and then we will see you in the next CB meeting, which will be October, right? October 11th. All right, thank you, everyone.